Today's topic is going to be trust basics. We get lots of questions about trust on a pretty routine basis, something that a lot of people want to know about. And oftentimes I will get folks, they'll just come into the office and they'll say, hey, John, I think I need a trust. Saying that is kind of like walking into your doctor's office saying, hey, I think I need surgery. Well, maybe you do. What's wrong with you? Right? It's a tool, and we got to figure out if that tool is appropriate. Right? Now, let's go, if we're going to talk about trust basics, we got to get basic, right? Where's this whole thing come from? Trusts are not a new concept. This actually comes from the Middle Ages. Right? So you go back to England, you got kings and queens and all of that sort of knights and the whole deal, right? Back then, the king is the arbiter of any dispute. Right? So if there's a legal problem out there, it's the king who decides that. They also had a tendency to get into some fights back then, the holy wars and all of that sort of stuff. And the king might grab up all of his knights, and of course the knights are the big landowners, right? They're the kind of elite of the community. And he'd get up all of his knights and he'd say, okay, go out and fight my wars. Well, this was not like they jumped on a C-130 airplane and flew to wherever they went. They got on horseback and rode across continents. And so those knights might be gone for many, many years. In the meantime, they've left their little serfs and peons in charge of their castles, right? Now, imagine, here comes that knight. He's coming back from the battles maybe 10 years later, 15 years later, 20 years later. And he rolls back up to the castle and he says, I'm home. Sir John has arrived at his castle. And the serf who's been hanging out at that castle this whole time says, I don't know what you're talking about. This is my castle. And we go, well, what do you mean it's my castle? And so you would end up with these property disputes between the landowners coming back. If you go all the way back, like the story of Robin Hood is basically this same sort of thing, right? Robin Hood goes off, and when he comes back, there's a dispute over the land ownership. And all of this stuff would get solved by the king. King gets tired of messing around with all of this, and so when the knights would head off for these wars, the king would say, look, we need to have something in writing that says, here's who's going to be in charge of these lands while you're gone. And so the knight would say, well, I, Sir John, am going to appoint my trusty servant, Emily Sabo, to manage my land holdings while I'm off fighting the wars. Well, what we have just done is we have created a trust. One person has transferred property to another for that other person to hold for the benefit of somebody other than themselves, right? So those are your basic elements to any trust. And a trust doesn't have to be anything complicated. If I were to grab a pen and I said, Miss Sabo, will you hold this pen for me? And if Marty needs a pen, let her use it. All right? We have now created a trust. So all trusts are going to have a few things in common. They're going to have they have one person who has property. That person is going to transfer that property to another, and they're going to hold, that other person is going to hold that property for the benefit of somebody else. Those are your trusts. So all trusts are going to have a grantor. That's the person that creates it. A trustee. That's the person who's in charge of it, and a beneficiary. And those are the people that receive the benefit of it. What I just described, where I just hand Emily my pen and say, here, hold this pen for me, that's a trust. It's just not in writing or anything. The law doesn't like that very much. You get into too many disputes over what somebody might have said and might not have said. And so we have something called the Statute of Frauds that says, wait a second, if we're going to get into this sort of trust business, this needs to be something in writing. And so now what we're actually going to have to actually write all of this out. I'm going to say, I, John Ross, have a pen, and I want Emily to hold my pen. And so I'm going to appoint her as the trustee over my pen. And so, all right, so now you're going to have this writing. But all of them are going to have these three basic things. But once this trust is established, once a grantor has transferred property to a trustee for the benefit of another, we now have a legal entity. It actually exists in the world, just like a person. It can own property, it can own bank accounts, it can own real estate, it can own checking and savings accounts. Think of it much like a corporation, right? If I go out and I create the John Ross Bakery Incorporated, and I go and register that through the Secretary of State and all that sort of stuff, I've created a legal entity. Trusts are the same sort of deal. All right, so beyond that, man, we can get into a few more little details here. You can pretty much start breaking these trusts into a couple of different categories. So one of them would be revocable. A revocable trust is a trust that the person who creates it can change it, amend it, or revoke it altogether anytime they choose. Okay, so I've created this trust between me and Emily Sabo, but I'm the one that created it. So at any time I can say, man, give me my pen back. Right? I can change it or amend it at any time. Most people understand revocable well enough. That kind of speaks for itself. Where most people get messed up is when they hear irrevocable trust. Irrevocable trust does not mean that it can't be revoked. That should sound somewhat weird. What irrevocable means is that it cannot be changed, amended, or revoked only by the person that created it. Right? So if I have, I've created this trust where I create it, I'm the grantor, Emily is the trustee, and Marty is the beneficiary, and I make this trust irrevocable. I cannot change it. Emily can't change it. Marty can't change it. But me, Emily, and Marty could change it. The three of us acting together could change it or amend it or revoke it altogether. So irrevocable doesn't mean that it can never be changed. It just means that it can't be changed by one person. It's going to take more than just that one person that created it. And there's some pros and cons that we can get into in some of this. So why would you do all of these sort of things? Why would you even bother messing around with all of this? There's a bunch of uses for trusts. The most common of which relates to what happens at your death. So, let's say that I've got a house, right? It's a house, it's just in my name. And I decide, well, you know what? When I die, I figure I want Emily to get my house. And like most people, if I'm thinking that way, my first thought is going to be, well, I'll do up a will, right? So I draft up a will, and I say, this is John, this is my last will and testament, and at my death, I leave Emily my house, and I sign that will, get it witnessed, get it notarized, and do all of that sort of stuff, okay? And here's this will, it's sitting out there. Then at my death, here's what's going to have to happen. It takes two things for a will to be valid. The first is I got to die. That should be relatively obvious, right? Before then, I could change it. So first thing is I got to die. The second thing is we got to probate this will. An unprobated will is just a useless, worthless piece of paper. And if you do not probate a will within a certain time period after death, you will forever lose the option to probate that will. In Texas, you've got 4 years after the date of death. In Arkansas, you've got 5 years after the date of death to probate that will. Until that happens, this is just a useless piece of paper. So if I've died, and Emily wants to get my house, then the first thing she's going to have to do is she's going to have to go hire her a lawyer. You cannot represent yourself in probate court. You have to have a lawyer. And so she's going to have to go get her a lawyer. She's going to go, they're going to file that will with the court. They're going to have a hearing. And at the hearing, Emily's going to present the will. Judge is going to review it. They're going to go over all of that. She's going to make some testimony about whether or not she's a crazy person or a convicted felon, or if she owed me any money or things like that that would disqualify her from being the executor. And once she gets past all of those hurdles, because I know Emily, she's not a crazy person or anything like that. So we're going to get past that. Court's going to appoint her as the executor. From that point, she's got 90 days in which to file an inventory of my estate back with the court. So she's got to go and prepare. Here's a list of everything that John has, and take that back to the court and get the judge to approve it. While that's going on, she's got to publish notice in the newspaper. This is the little thing you'll see in the back classified ads that says Emily Sabo was appointed as the executrix of the estate of John Ross. That's what's called the notice to creditors. This is so that anybody I owed money to can now come and file a claim against my estate. And we have to give them a period of time, which can range anywhere from around 3 to 6 months, depending on which side of the state line you live on. And then after all of that, we've made an inventory of the estate. We've notified the creditors. If there were any creditors, we pay those people off. We pay out the costs of the probate process itself. And once all of that is done, now Emily can deed the house to herself. Well, that seems, if I'm thinking about it, and I'm like, for me, this was very easy on me, right? Because I had to do two things. I had to sign the will and die. Easy breezy. That's it. But what I did do is I pushed all of that work down to Emily. Now, I will say that in both Arkansas and in Texas, the probate process is not too bad. It's relatively simple. I mean, I just described the process, and as long as nobody's fighting about it, other than it just taking some time and costing a little money, it's just a process. But I might be thinking, you know what, that's a little too much work. I would rather Emily not have to do that. So I might be looking for a way to transfer my property automatically to Emily where she would not have to go through that process. There are several ways to do that, but since today's topic is trust, now I'm back around to the trust. If I created a trust while I was alive, so I've got this legal entity here, and maybe this legal entity, this trust, says that this is John's trust, and it's going to hold title to his house. And as long as he's alive, it's his house. And if he wants to rent it or sell it or live in it or burn it to the ground or do whatever he wants, it's John's house. He can do with it what he wants. But when he dies, this trust and everything in it is going to belong to Emily. Well, that happens according to the trust. So as soon as I die, by the very terms of the trust, it says, John's dead, now this trust, everything in it belongs to Emily. So I die, it's her house. It's over. Now, I had to set all of this up on the front end. I had to retitle my house on the front end. So I ended up having to do the work on this, but then Emily didn't. And so the most common reason people will use a trust is to make that transition at death nice and smooth. This can be particularly important in a place like Texarkana. A state court can only deal with property that is located in that state. So let me change my facts up, and let's say that instead I've got my house, which is in Texas, I've got a rental property that's in Arkansas, I've got some oil and gas in Oklahoma, and I've got a gator farm in Louisiana. And I have a will that says I leave all of this to Emily. Well, I just described the probate process, right? Go get appointed and all of that sort of stuff. But once she does all of that in Texas, and she is the Texas appointed executor, that gives her the power to transfer the Texas property. But that Texas court doesn't have any power over Arkansas, which means she's going to get to go probate that will again in Arkansas and go through the process a second time. And then she's going to get to go to Oklahoma and do it again to transfer the oil and gas rights. And then she's going to get to go to Louisiana. And in Louisiana, they don't call it probate, they call it succession. And she's going to get to go do a succession in Louisiana. Now, that's a much bigger deal, right? I mean, I said earlier that, hey, probate in Texas, Arkansas, not too big a deal. Yeah, it's not, unless you got to do it 4 times for one death. All of a sudden, that can get really, really expensive. I have had that exact scenario before. And I was able to do the Texas side and the Arkansas side. We ended up having to hire another attorney up in Oklahoma City to handle the Oklahoma property, and then we had to handle some Louisiana attorney to handle the Louisiana property. And that by the time they paid everybody involved in all of this, it was pricey. And in fact, it almost was at the point where, like, the minerals in Oklahoma, they really weren't producing that much. It was like $50 a quarter, And so you say, you can't get the $50 a quarter if you don't go through this process, but the process itself is going to cost $2,500. How many of those quarters you going to have to get $50 before this even pays for itself? So you can run into those sort of problems. So probate avoidance like that can be a big deal. The other thing about the whole probate avoidance is this whole notice to creditors. So I had a client who was dying. He knew he was going to die. There's no question about it. In the year or two prior to leading up to this time frame, he had managed to rack up quite a bit of debt out there. They've been living off some credit cards and things like that. And so there was probably upwards of about $200,000 in unsecured debts. Just credit cards and signature loans at the bank and that sort of thing. And they did this in large part because they were trying to make the best out of the last year. Meanwhile, though, they do have some assets, right? They've got some real estate, they've got some CDs at the bank, they've got some things. If you owe anybody any money when you die, well, they're going to have a claim against your estate. But that word estate right there, they have a claim against what goes through probate. If property does not go through probate, there's nothing for them to claim. So prior to his death, we were able to set up a trust, transfer things like the real estate, some of the financial assets into that trust so that they would pass to his heirs at his death. And because at his death there really was nothing in his estate, his death acted like a bankruptcy. Debts do not pass to your heirs. And so either there's money to pay them when you die, or they don't get paid. And, I promise, Discover Card didn't lose a meal off of this deal. They also didn't get paid back. So they wrote that off, took the tax deduction, and went on their merry way. Meanwhile, though, his family, they were able to take those assets and go on about their way. So you can also avoid the creditors by doing something like that. Now, when I tell that, particularly to an older crowd, I often get a lot of folks that say, well, that's all fine and dandy, John, but I don't owe anybody anything. At this point, I've got my house paid off, got my car paid off, I pay off my credit cards. If I even use them, I pay them off at the end of the month. I don't owe nobody nothing. It's great. If you're still operating a motor vehicle at the age of 85 years old, the chances of you being in a car wreck are the same as my 16-year-old. Now, that doesn't mean you're a bad driver, but it means you're statistically likely to be a bad driver. There's some 16-year-olds that are great drivers. None of mine have been. It doesn't mean that, one of them couldn't be. It's just that they generally aren't. The difference, though, is that although my 16-year-old is likely to kill somebody in a car wreck, they will most likely walk away from it. If you kill somebody in that car wreck, you probably are going to have died in the car wreck as well. And you may not have owed anybody the moment before your death, but your death has created a debt, the wrongful death lawsuit that is going to be filed against your estate. And if those assets are passing through probate, then you can guarantee that one of the claims that's going to get filed in that probate case is going to be by the plaintiff's lawyers representing the people that you injured or killed. So even though you don't have any debts right now, that doesn't mean you couldn't at some point in time. All right, so all of that goes to the main reason most people set up trusts is probate avoidance. Now, there's lots of other things, though, that you can do with a trust, because really, when it all boils down, all we're talking about is a stack of paper, right? And it's a stack of paper with rules. Whatever is written on these pages, these are the rules. These govern whatever is in the name of this trust. So, for example, let's say, and you're going to have to stick with me on this, but let's say that I create a trust for the benefit of Emily. And I say, I want this money to be used for Emily. But the person who's in charge of this, the one thing, they can spend it on Emily in any way, shape, or form, as long as they don't spend it on her in a way that would affect her eligibility for any government assistance like Medicaid. Right? So they can use it for her in any way, but if they were to use it in a way that would affect Medicaid, they're prohibited from doing that. Well, you know what that does? Let's say that Emily has had a stroke, she's at the nursing home, and she's trying to qualify for something like Medicaid. And Medicaid wants her to be basically broke. Right? They say in order to qualify for Medicaid, you can have a house, you can have a car, you can have $2,000. So that's basically broke. And then here's this trust, and it's got all this money in this trust that's there for Emily's benefit. And so Medicaid, they want to look at this trust to see if they can say, well, look, you need to spend this money first. But then they look at that trust, and the trust by its own terms says, well, yeah, this could be used for Emily, but not in a way that would affect her Medicaid. And if you're prohibited from using it in any way that would affect her Medicaid. And what that does is that turns it into a non-countable asset for Medicaid purposes. This is what's called a special needs trust, or special needs language in a trust. Often called a supplemental needs trust, because by the terms of the trust, it's supplementing any other government benefits. It says, hey, if you're getting government benefits, hey, let the government pay for those things, and this will pay for anything else that the government's not already paying for. Special needs or supplemental needs trusts have been around for a long time. But think about it. Let's say that, let's take my own planning, right? My own personal stuff. I say I leave everything to the wife, right? It's hers. She can bring her next husband to the funeral, whatever, right? I die, I leave everything to her. But what if we're in a car wreck and I'm dead and she has a catastrophic brain injury? Or what if she has Alzheimer's and I'm her spousal caregiver? Spousal caregiver's life expectancy is only about a third of the life expectancy of the person with Alzheimer's. You get Alzheimer's, you're going to die in 10, 15 years. If you're married to somebody with Alzheimer's, you're going to die in 3 years. Yeah, those are the real numbers, right? And also, if I get into this car wreck and I'm dead and Lisa has a catastrophic brain injury, she's probably going to need something like nursing home care. So if you look at my planning, it says, when I die, I leave everything to Lisa. But if she's incapacitated, I want it held in a special needs trust for her benefit. And bam, that would shield the assets. Now she could qualify for Medicaid without ever having to use those. Same thing if you have a child with disabilities or anything like that. So my point is you can start wording these trusts. You can make it say anything you really want. Have one that we're dealing with right now. Hopefully, it's nobody in here. No, just making sure. But basically, the way it's all set up is, guy's got a couple of kids. He doesn't really like the kids all that much, but he particularly doesn't like one of the kids' spouses. And so he has said, I leave all of this stuff for the trustee to hold, and my child can get $2,000 a month, no more, no less, and that $2,000 a month will start as soon as their husband's dead. But you can say it. Yeah, that's kind of an extreme situation, but hey. Once again, you can. You may say, okay, well, that's a little weird. But, a lot of times you may have folks that maybe are not financially responsible enough to manage assets. They may be minors, right? I mean, if you're leaving assets maybe to a grandchild, or maybe you're leaving it to the parent of the grandchild, but the parent predeceases you. Right? And if the parent predeceases you, then it's probably going to end up going to the grandchild. If the grandchild, if your son's daughter, your granddaughter, is 8, you didn't leave it to the granddaughter. You left it to the granddaughter's mama, who, of course, brings her next husband to the funeral and his 3 kids. And what you left behind for your dead son's daughter is now what you left behind for your dead son's daughter's mama's new husband's 3 kids. And so you might be thinking, yeah, you know what? Instead of just leaving it, if this lands in the hands of somebody who's under whatever age, minimum would be 18, although I have 18-year-olds and they're morons. You can say if they're under whatever age, maybe 18, 20, 25, 30, I don't care, then here's who's in charge of it until they get there. That's a trust. You're now creating a trust for the benefit of that minor because they can't be in charge of it themselves. I've got one that I help a bank manage. The bank's in charge. They're the trustee. And it's because the heir in this case is addicted to drugs. We cannot give her money. You give her money, she will smoke it. It's what she does. So we can buy her food, we can do things like that, although generally the bank has to watch her eat the food because she'll sell the food and smoke it. So now, that being said, I mentioned bank. All trusts are going to have somebody who's in charge of it. That's the trustee. It does not have to be a bank. Many times I've talked to folks and they say, well, I thought about doing a trust, but I didn't want to turn everything over to a bank. Well, you don't have to. You name the trust, right? If you look at my own personal trust, the trustee is me. I created it. I named myself as the trustee. So I'm in charge of it. In fact, I'm also the beneficiary of it. And if I can't be in charge of it, then I've named somebody else to be in charge of it. So you get to name whoever you want to be in charge of it yourself, and if you can't do it, you can name other people. Now, you can use a bank, and that many of the banks, if you're looking at the name of the bank, and you see it say something like XYZ Bank and Trust, that and trust part means that bank typically means that bank is going to offer some sort of service where they would act as the trustee of a trust. That can be very beneficial in the right circumstances, right? There's something to be said for not having a dog in the fight. If I leave everything to our 4 kids, maybe they get along. and divide everything equally and nobody fights about it, or maybe they don't. And if I think that maybe they won't, I might want some third party to step in. Well, like in my case, I'm an only child. I don't have a brother or a sister that could do it. So I might say, yeah, okay, I'm going to get a third party like a bank to come in and do it. And of course, if I talk about that with a client, a lot of times the natural response is, well, isn't the bank going to charge a fee for that? Yes. When the bank steps in, not right now they're a name on a piece of paper, but if they were to step in and be the trustee, yeah, they would charge a fee for that. That's what I call a known fee, right? The bank will tell me how much they will charge. All I got to do is call and ask them, hey, if you become the trustee, how much would you charge to manage this trust? And they have a schedule, and they will tell you, we would charge this amount. How much would the lawyers charge fighting between my children? If I appointed one of them and their sister was unhappy about it and they both end up hiring lawyers and they fight about this for a year. Now, they're not charging a fee as trustees, but that's an unknown fee. The risk that they start fighting amongst themselves, there's a cost to that as well. That's an unknown cost. If they get along well and they split everything nice and simple, great. It was actually the cheaper alternative. If they get to fighting about it because one of them, is still mad that they got a Honda when they turned 16 and the other kid got a Mustang, well, yeah. And I say that I had a contested guardianship case. These two sisters hated each other, fighting over their dad. And I was walking through the mall in Texarkana, walking through the mall with two of my little children at the time, and the other sister runs up and just starts chewing my tail in the middle of the mall, talking about what a bad person her sister is and how awful she is. And the reason she's doing all of this is because I was the pretty one. Now, this woman was 78 years old. And they're still fighting like a couple of 12-year-olds. Yeah. And so, yeah, that was a situation where Dad had appointed one of them. The other one was super mad about this. They decided to fight about it. This case started probably about, I think it's probably been 7 or 8 years ago. I fired my own client after about 6 months because I didn't like her any more than her sister. And I just didn't want to be a part of it anymore. But because my name is still associated with the case, I will still occasionally get a notification from the court or something. And the most recent one came about 6 months ago. They're still at it. 7 years later. He's been dead for 6 of them. They're still fighting over it. The only people who have inherited from their dad have been lawyers. I can guarantee it, because he didn't have that much. So again, there can be some benefit to using a corporate trustee. In almost any case, one thing I would recommend when it comes to naming trustees, the last named alternate trustee be a bank. Because you know what? Banks don't die. Right? So if I say, well, it's me and my spouse, and if one of us can't do it, then the other one can do it by themselves. And if neither of us can do it, then child 1. And if child 1 can't do it, then child 2. And if child 2 can't do it, then child 3. And if child 3 can't do it, then child 4. But what if we all take a flight to Malaysia over the South China Sea and plane disappears? It does happen. Who then, right? But so if I've said, if it's not me, then the spouse, and if it's not the spouse, then child 1, then child 2, then child 3, then child 4, then if none of us can do it, then XYZ bank. Bank doesn't die. And so in the worst case scenario, there's still somebody who could step in and administer everything. So whether you're talking about, I typically think of that in context of a trust, but it would also equally apply to executors on an estate, although many banks will not actually act as the executor. They don't like to get involved in the court side of things. They don't mind being trustees because they don't have to be involved with the court. The whole benefit of using the trust. So, any questions about any of this so far? Yes, sir.
What if some of the family members sues the bank because they don't like where they're doing it?
Right. So his question is, if I've appointed the bank, what if they sue the bank? Now, of course, first a couple of things on that. One, typically the banks are, most of the time, there have been some exceptions here recently. I'll tell you about one here in a second. But for the most part, the banks, they have what's called a fiduciary duty, meaning they have to act in the beneficiary's best interests. Now, that doesn't necessarily mean that the beneficiaries are happy with what the bank thinks is in their best interest. Right? If the one kid's a crackhead, and the best interest, the bank figures their best interest is to get them a Happy Meal once a week so that they'll have food instead of giving them $20, which they'll buy crack with. The crackhead beneficiary probably does not think that's in their best interest. They think in their best interest they need $20, right? And they might turn around and sue the bank. Well, one thing about it, the bank's doing what they're supposed to do, so they're probably going to lose on that. There is a case out of Dallas here recently where a bank was I think they were actually the executor of an estate. J.P. Morgan Chase. They abused their position. They milked the estate for everything it was worth. It was a big estate, multi-million-dollar oil family money. And they worked on it for about 4 years, still weren't making distributions. There were million-dollar pieces of art that were still sitting in a vault at the bank 4 years after the date of death that hadn't been distributed to the family. In this case, it was a blended family, and yet both the surviving spouse and the kids from the previous marriage all got together and sued the bank and won. Jury awarded $400 million in damages against the bank. But you know what? Banks got insurance. They can pay it. So the one thing about a bank is, if the bank is acting up, they could sue the bank. If they win, if the bank is really acting up and they win that lawsuit, the bank actually has insurance to pay that. If I've appointed my cousin Stewie, and cousin Stewie mismanages the trust, well, they're going to sue cousin Stewie as well, right? But you get a $100 million judgment against cousin Stewie, who cares? Cousin Stewie just going to file bankruptcy and go on down in a merry road, So they can sue the banks. In fact, you can sue any trustee. It is somewhat more difficult to sue. Now, and on that same note, again, you can make this trust say whatever you want. So, for example, I could say, well, I'm going to create this trust. It's for your benefit, but Emily's in charge of it. And of course, I can't take away your right to sue Emily if you think she's doing wrong. But in this trust, I'm going to say, if you do sue her and lose, then you're no longer a beneficiary of this trust. And instead, it's going to go to this lady. That's what's called an interim clause, also called a no contest clause. Basically says, you can fight it, but you better win. Because if you don't, you're going to lose. You're going to lose it all. That can be a pretty powerful incentive. And so again, you can start writing into things. If you're worried that people are going to fight about it, you can disincentivize them by saying, hey, if you do fight about it, if you lose, you're out. And you can even go as far as say, not only are you out, but your descendants are out, the whole clan of you is out. Leave it all to a charity or something like that. I mean, there are ways you can do that. So, That answer your question? Sure. Absolutely. Any others on any of that? No? So, again, trust, saying the word trust is like saying the word surgery because they do get very, very complicated beyond this. There are lots of things because, again, you can say anything you want in this stack of paper. And if you know tax law in a lot of detail, if you know Medicaid law in a lot of detail, if you know lots of things in a lot of detail, you can start creating trusts that do all kinds of things. For example, there's something called a Domestic Asset Protection Trust, or a DAPT. And this is where I create a trust, name myself as the beneficiary, but then in the trust I say, the money is for me and for me alone, and cannot, under any circumstances, be used to pay one of my creditors. And so, let's say that I created that type of trust, transferred my assets into that trust, then walked over and punched you in the mouth. You know, you could sue me, and we've got all these witnesses, so you're going to win the lawsuit. You're going to get a judgment against me, but your judgment's no good against my trust, because my trust says, well, although it can be used for John, it cannot be used for John if that purpose is to pay off a creditor. Time limit on trust. Ooh, good one. All right, so there is a concept in law that will cause many law students to get the first C they've ever had in their whole life. Because, you know, a lot of law students are kind of nerds, right? They're the kids that did real good in high school and they got real good grades in college, and that got them into law school. And so many of these kids, they're A, B students. They've never seen a C in their whole life until they get into property law and they hear something called the rule against perpetuities. All right, so going back to those knights and the king, right? So I'm Sir John, I'm the knight. And the king has told me that I've got to write out this plan. And so I write out this plan and I say, I, Sir John, have these land holdings which make me and my family very rich and powerful. And so they're for me, and if I die, they go to my, of course at that point you had to leave it to your only boy. So yeah, I'd leave it to my sons and his sons and his sons forever. And what that meant was my family would stay rich landowners forever. A couple of little boats left England and they floated across the sea and they ended up over here. And one thing we really didn't like about that part of the whole reason we got on those boats and floated over here was because we didn't like some of those rules. Like, for example, these rich royalty people staying rich royalty people forever. And one of the ways that they stayed rich forever was by creating trusts that would last forever. They could shield their assets, they could stay rich landowners forever. And so when we came over here, when they first started creating some of these laws related to property and things like that, they created something called the rule against perpetuities. It says that if you're going to create something like a trust, yes, the trust can hold it, but that trust is going to have to terminate at some point in time. The classic rule against the rule against perpetuities reads like this. It says that the property must vest, meaning that it lands in the hands of somebody. The property must vest within a life in being plus 21 years. What in the world does that mean? So, the easiest way to think about this is, so I create a trust and I say that it's for me and my wife and our kids and their kids and their kids forever, right? But when I create this trust, all I have are me, wife, and our kids, right? So that generation right there, my children, that's the youngest life in being. That's the youngest generation that's alive at the time I started this. So it would be all of their lives plus 21 years. So a life in being plus 21 years. But what if I didn't create this yet. I waited, and one of my kids had a child. So now I have a grandchild. All right? Now it's that generation. Not that child's life, but that generation's. Everybody in the generation of my grandchildren, their lives plus 21 years. So all of my kids would have to be dead, all of my grandkids would now have to be dead, and then another 21 years would pass, and then whoever it would have to end. All right? So that's the rule against perpetuities. Law professors love to write exam questions about this. John creates a trust for the benefit of Emily Sabo, who at the time the trust is created has 3 children and 4 grandchildren. And one of the grandchildren has a child that they adopted. You get into, okay, and so when does this trust expire? So that's the rule against perpetuities. Some states decided, you know what, this doesn't make any sense. First of all, it's impossible to understand. So we're going to come up with some different alternatives. So for example, in Arkansas, you have a choice. You can either go with the rule against perpetuities, or you can just pick 100 years. You can just say, nope, this thing will terminate in 100 years. Or you can say it'll terminate within a life in being plus 21 years. So you can do it either way. In Alaska, a couple of years ago, they decided to change their laws and make the rule against perpetuities 300 years. And so if you create a trust that is governed under Alaska law, it can go for 300 years. Not to be outdone, Nevada came in a couple of years after that and said, you know what? We're out. We're doing away with it altogether. So you can create a trust in Nevada under Nevada law that would never terminate. And again, we go back to this whole thing about you can write whatever you want into this trust. So for example, I can sit here in the state of Texas and create a trust, but in the trust, I say all of this trust is governed under the laws of the state of Nevada. And so now, although I'm in Texas and my property is in Texas, I could create a trust that is governed under the laws of a different state. So that was a good question on that one. You've got domestic asset protection trust where you're trying to shield your own assets. There are ways you can use trust to shield from things like the estate tax. That used to be a much more popular use of trust was tax planning. I used to do a bunch of them for tax planning. Under the current law, each person can die without having to worry about the estate tax as long as they have less than $11.2 million. Most of y'all gonna slide right under that. And if you're talking about a married couple, then it's double that, right? Because for a married couple, now it's $22.4 million. And most of y'all definitely gonna slide right under that. There's not a lot of need for estate tax planning like there was, say, back when I started practicing law, and anything you had over $625,000 was subject to a 45% tax. Well, it's a big difference between anything over $625,000. That's roughly about a little more than a third of everybody that dies in the United States every year has more than that. Compared to the number of people that are subject to the estate tax right now is 0.0002% of the entire population of the United States. Little bitty tiny group. So, but you can do it for those sort of things as well. So there's lots of stuff you can do with trust. Like I said, that stuff gets into some pretty complicated things, but they are very powerful tools. People often think that they are the use for the rich. They're not. Historically, they used a lot of trusts for estate tax planning. That's where people got the idea that, these are things for rich people. But they're also for people that want to try to protect their assets from long-term care, try to protect their assets from creditors, particularly at their death, want to make it easy for the people they leave behind without having to go through a lot of court process after their death. Protect beneficiaries who maybe have their own issues. So there's lots of reasons to use a trust, and you don't have to be rich to worry about those. We can all have those sort of issues in our lives. So, any other questions? Yes, sir.
John, is there ever an occasion where someone would benefit having a will versus a trust?
So the question is there a situation where somebody would be better off with a will versus doing a trust? So take my own family, right? So my grandfather, he was 92 years old when I did a will for him. He had one before then, but he wanted to make a few changes or whatever. And so he calls me up. He knows I've graduated from law school. And he says, hey, John, I want to make some changes to my will. He lived in Granbury, Texas. All of his property was in the state of Texas. In fact, he just had 2 houses there in Granbury, Texas. Had some money in the bank. And he's got 2 kids, my dad and my aunt. Both are perfectly healthy, happy, all of that sort of stuff. And he's got a grandson who's an attorney that kind of specializes in this stuff. And so, in his deal, it didn't really make sense for him to do the work to set everything up with his age, with the situation, with the facts. I mean, I know this may sound a little weird, but, I figured at 92 that he wasn't going to be around all that much longer. And frankly, it was just going to be easier on everybody for him to sign a will, die, and let me step in and handle everything and get it all transferred to my dad and my aunt. So in his case, I just did a will. Nice and simple. But I will tell you one thing about it, and this kind of does bring up a good question. So a lot of times people will say, well, John, will or trust, and here's my reply often, both or neither. And that may sound a little strange, right? So let's take my house. Let's say the only thing I have in the whole world is my house. And you know what? I'm going to leave everything to my 2 kids. They're both perfectly healthy, happy adults. And I'm not worried about any situation for them. And frankly, I'm not worried that circumstances are going to change. All I really want to do is make sure they can just get my house when I die. Well, in Arkansas, for example, I could do something called a Beneficiary Deed, where I just go file a deed at the courthouse that says, when I die, my 2 kids get the house. Done. In which case, I needed neither a will nor a trust. I still transferred the house to them outside of probate, nice and simple. Now, if one of them becomes disabled or things like that, we're going to probably have issues. But for just a nice, simple transfer of that one asset, that was easy breezy. And so, in fact, that was a better option than either a will or a trust. The reason so on the one hand, I often say, if you're asking me between a will or a trust, there's the third option of neither one and some other way of transferring assets. The other reason I say is both, because let's say that I've created this trust and I've gone through and I've taken the time to transfer all of my accounts. My bank accounts are in the name of the trust. My real estate's in the name of the trust. Everything is tied to this trust. Right? And it says that when I die, I'm going to leave everything to the people at this table. And I die, but the reason I die is because I was killed by somebody who was texting and driving. And they crashed into me and killed me. Well, you know what? 6 months after my death, they're finally going to have settled the wrongful death lawsuit against the driver of that automobile, and there's going to be a check. There's going to be money, and there's no way I could put that money in the trust before I died. It's physically impossible unless you got a Ouija board or something like that. It's just not going to happen. So it's possible that even after setting up that trust, that something's not in the trust. So even if I've done that trust, I may want a will as a backup. It could be a very simple will. It could just be a will that says, hey, this trust says who gets my stuff, and so if there's something that's not in the trust, I leave it to the trust. Nice, simple little will, right? But that's why I often say neither or both. Because if you could benefit from a trust with the kind of planning that you could put in a trust or the planning that you could put in a will, between the two, the trust is probably the better option. There may just be simpler alternatives out there, like beneficiary deeds or ladybird deeds on the Texas side or things like that are just simpler options than both of those. So, anyway, long answer to your relatively simple question. But that's how I do. Anything else? Yes, sir.
3 years ago, we secured a reverse mortgage for our home. And in doing so, we had to take our home out of the trust. And I think you recommended at that time we could put it back in if we wanted to. Is there a reason for doing that?
So here's something that I have run into, and it's not just a reverse mortgage situation. So there's a federal law out there. This was back when, after the whole real estate collapse, and all of these banks were doing shady stuff with mortgages and things. They passed a bunch of laws back then. And one of those rules that's in that federal law says that a bank cannot refuse or affect a mortgage in any way, shape, or form solely because your property is in a trust. Long as it's your trust and you can do with it what you want, you can have mortgaged property in that trust. Whether it's HELOC, whether it's reverse mortgage, whether it's traditional mortgage, home equity, it doesn't matter. Any type of home line of credit and a trust like that are no problem. Thing is, banks just like to do whatever they want to do, regardless of whether or not it follows any of the rules. So I've had many times where maybe we created a trust, transferred the property into the trust, and then at some point, maybe they wanted to get a home equity loan or a reverse mortgage or something like that, and the bank says, well, we're not going to do it unless you take the property back out of the trust. Well, you could sit there and argue with them all day long, but if you just want to get the money from the reverse mortgage, the simplest thing is to just take the property out of the trust. The beauty of it is, though, you can take it out of the trust, get the reverse mortgage, and the federal law says you can stick it right back in, and they can't do anything about it. And so sometimes it's easier to just take it out, say, okay, fine. Let them process the mortgage, and then just put it back. Now, again, depending on the type of mortgage that may or may not be appropriate, but that still having the property associated with the trust is going to make it easier to transfer at death. That's the whole point of it. And so if there's going to be some equity in the property, where the family might want to be able to sell the property, pay off whatever debt is on it, and keep the proceeds, they can either do that automatically because it's in the trust, or at your death, they can go and probate the will, go through that process. Once they go through that process, then they could sell the property. The problem is that the mortgage company may have already foreclosed on it by that point because of the time delay. So, yes, I would probably get it back in. I would probably get it back in. But that's going to be a person-by-person situation. Somebody else over here? Yes, ma'am.
I wanted to ask, is the trust not dispersed at your death? Why would it go over?
So her question is the trust not just dispersed at death? Well, again, this is going to go back to what does the trust say? So I could say in my trust that it's mine as long as I'm alive, and when I die, this trust is over, and Emily Sabo gets whatever's in it. Bam, it's hers. Or I could say, it's my trust, I can do with it whatever I want. When I die, my trust just becomes Emily's trust. Now, it's either way, it's still going to Emily. On the one hand, if we terminate the trust and just dump it all out to her, well, she can do with it whatever she wants. She doesn't have to open accounts in the name of a trust or anything like that. But if she is, if she's in the middle of a lawsuit or a bankruptcy, or maybe she's in a nursing home at the time this happens, and I just terminate that trust and dump it to her, well, I probably just terminated it and dumped it to the facility. So if I continue it in trust, maybe I could shield it, where she could still do with it what she wants, but just in case, if she's in a nursing home or she's in bankruptcy or something like that, maybe I've protected it for her. So again, you could do it either way, and there's some pros and cons to each. So yeah, but you could terminate it, dump it out all right, or you can continue it on. And by continuing it on, you can create some protections through the years. Is there any other? Did that kind of answer the question? Sort of? Yes, sir.
How often should you review a trust or a trust?
How often should you review a trust or look at it, update it, things like that? It's hard to say. Estate planning health. How healthy your estate planning is very similar to how healthy your body is. Occasionally, it may be a good idea to go get a checkup. Now, depending on who you are, maybe you should get a checkup once every 5 years, or maybe you should get one every 6 months because you've had some other issues going on. So there's no right or wrong answer. I often tell my clients, look, you know what, if you give me a call maybe once a year, once every other year, something like that, and just say, hey, has anything weird happened that I need to know about? And I can look back and I can look at my files and I'll have a pretty good idea of what the family dynamics were and things like that. And I can say, hey, everybody's still good, And so certainly, occasionally like that. Definitely anytime there's a major change in the family dynamics. Somebody gets sick, somebody dies, some sort of tragedy has happened. Those sort of things definitely you want to look at. Because often there may be some changes that need to happen. One of the things I see a lot right now is people that maybe they created a trust in 1990. They did it in large part because it's got a whole bunch of estate tax planning. Going back to the whole $625,000 exemption, right? So they got this big, thick stack of paper with all this complicated tax planning because at the time, they had a net worth of about $1 million. And so there was some significant tax liability there. Well, now with a $22.5 million exemption, all of that tax planning is irrelevant. And so often we can simplify a lot of that stuff. Often they did that trust back when they were 55 and looking forward to retirement. Now they're 85 and worried about long-term care. They don't care about the estate tax anymore. When they did the trust, they were focused on the estate tax. Now they're worried about things like what happens if I go to the nursing home. And there may not be any planning related to nursing home care in that. So it's hard to say in there, but occasionally is a good idea. It's going to vary by person. But once a year, once every other year, going back to the person you visited with in the past and just saying, hey, anything changed that I need to know about? Because I had somebody call me the other day, and I had done some tax planning for them years ago, and they did. They called and they said, hey, with this whole Trump thing, do we need all of this stuff? And I was like, no, really, we could actually probably get rid of a lot of that and simplify a few things. They were like, okay, well, that sounds good. So, yeah, that answer your question? Awesome. Yes, ma'am.
What about if you're trustee over the money trustee? Can you take some of that money and invest?
So your question is, what if you're the trustee? What can you do as the trustee? So your job as the trustee is to manage the trust assets for the benefit of the beneficiaries. And you are supposed to manage those assets, again, going back to what I was talking about earlier, in everybody's best interests. Which means, you shouldn't stick, if you've got a bunch of money, putting it all in a checking account that's not earning interest, that would not be in anybody's best interest. Because it's not earning some return on there. On the other hand, taking it all and putting it in Bitcoin, the cryptocurrency, that might be a little dangerous, right? That might be going too far. You could make a whole bunch of money really fast, or you could go broke really fast. And so some medium in there, again, like you would with your own assets. In fact, one of the rules is what they call the reasonably prudent investor rule. And so you would manage those assets and invest those assets as a reasonably prudent investor would under the same circumstances. And so, yeah, that means having some in cash, having maybe some in some secure things like bonds, and some maybe a little bit more, maybe some mutual funds that are going to get a little more growth and things like that. A nice diversified portfolio, as the financial advisors like to say. So yes, you're supposed to do that. Now, as the trustee, as the person that creates the trust, I could put restrictions on there. I could say, I'm creating this trust for Emily's benefit. I'm appointing you to be in charge, and you can only invest these assets in Bitcoin. In which case, you're stuck. You got to put everything in Bitcoin. You got to figure out how to do that, and you got to build a server farm in your basement so that you can, yeah. Anyway, but you can say all of that sort of stuff. But generally, yes, you're in charge of investing it prudently. All right, anything else? I'll tell you one quick story, and then we're going to get out of here. So this goes back to your comment about when do trusts terminate. This is 1916, I believe. I'm going to mess my dates up because I can't do the math in my head. It's either 1916 or 1918. But we'll say 1916. This guy had $1 million in 1916. That's a bunch of money in 1916. And by all accounts, he was one sour individual. He did not like anybody. He did have family. He didn't like them either. He created a trust. And by the terms of the trust, there was a bank that was going to manage it as the trustee. They were to invest the funds. The trust was for the benefit of his family members, but they could get none of it. None of it until they were all dead, plus 21 years. At the time of his death, he had a grandchild, I believe a grandchild or a great-grandchild, I don't remember which, of his grandchild, who died in 1985, I think, or 1986, somewhere right in there, say 1985. And that was the last of the grandchildren to have died. So that started the 21-year clock in 1985, and so that got us to 2006. And in 2006, the trust finally terminated, and the bank tracked down the 8 final heirs. There were only 8 people that were related to this guy through this trust. Bank found all 8 of them and wrote each one of them a check for $40 million. Yeah, the old rich uncle, that's it. That was a real deal. Anyway, just kind of, but that was the rule. He set it up so that nobody got nothing until the rule against perpetuities. Wonder if what he would have done had he been alive today, where he could have set that up in Nevada, where it would have never gone to anybody ever. Because he might have been the kind of guy to do it. It sounds like. Anyway, hope y'all enjoyed it. We're going to be doing these, I think, basically once a quarter. And so we'll be back sometime in the summer. I don't know when. But anyway, hope you enjoyed it. We'll see y'all next time.